Hello, landlords. Good to see you. It's Ernie Garcia, landlord attorney, and we're here on a Friday. Another unexpected rescheduling. I normally do these on Wednesday afternoon, but like last week, I was caught in trial. We had a 3-day jury trial that we were scheduled for on Tuesday. It went clear through Thursday. And so here we are on a Friday on our YouTube Live at the end of the week. For those of you who submitted questions in our Facebook group, Texas Landlords, I've got those here. I will be answering those questions for you in this live. For those of you who did not get a chance to submit questions through the Facebook group, don't hesitate to join the chat, add your questions here. I will get to those questions before we reach the end of the live stream. So today's topic is whether it's safe to lease residential rental property to a business. And the reason we put this content out is because these kinds of things happen, and it isn't until the landlord is already in trouble that I get to offer some advice or give the landlord an opportunity to ask the kinds of questions that I think are important for a landlord in a situation like this. So what I'd like to do is offer a few things for landlords to consider if ever they are approached by a company that wants to sign their residential lease. So I'm going to go through 5 questions that you should be asking yourself if this is the case. This isn't a matter of should you shy away from signing commercial contracts for commercial property. Absolutely, you want businesses signing your commercial lease. The question is, why would it ever be appropriate, or when would it ever be appropriate for a company to sign a residential? And please don't take any of this to mean it's never appropriate, but these things should be taken with a grain of salt. They sometimes go very, very wrong. So the first question is, does the deal already sound too good to be true? Is your spidey sense tingling at the sound of what this potential tenant is talking to you about? For example, do they say things like, oh yeah, I've got lots of these all over the city. Do you know of any? Are any of them available for you to go check out to see kind of what they're talking about? If not, then it might be too good. And I would definitely investigate claims like that. If a business is using your property and they say things like, well, in a couple months, we're going to go and just pay the rest of the year in advance. We do so much money. But you can't confirm this or verify any of this. Again, too good to be true. Because here's something that sometimes people get a little lazy on. Because it's not a conventional tenant, landlords sometimes don't do the conventional background check on the individuals who are applying because they're not living there. They're conducting their business there. And so they figure, oh, well, I don't have to do the same kinds of checks, but you absolutely do. If they claim that their company does over $1 million in revenue every single year, so why would it be difficult to pay your $2,000 a month a house? You're going to want to confirm these things. And if you can't, probably too good to be true. So a company does not live on residential property. People live on residential property. So who are the people who are going to be identified in this lease? This is another essential. You need to know who's on the property at all times. And if you don't, that's a problem. And so whenever you get someone who wants to sign a lease as 123 Industries LLC and nothing else is disclosed to you, again, that's problematic. What people are going to be there? Who can you expect on the property at all times? If these things aren't forthcoming or will not be disclosed to you, again, I don't know that I could recommend that you sign this lease. Remember, this is a residential property that a business wants to sign for. Now, there's a couple of businesses that come to mind just right off the bat. The first is a subleasing company. So they do short-term rentals for other parties. And so you think, okay, well, I'm never going to know who's there because it's always going to be somebody different. The question for you is, does that make sense for you? Do you feel confident that the people they're going to bring to your property are people you would want on your property? If you can't answer that question, then maybe you shouldn't be signing that lease. Another has to do with the medical field, and there are certain companies that'll come and say, well, I run a business and it's kind of a nursing care business, so the residents are actually people who are under hospice care or some kind of adult care, almost like a nursing home. Your house might have to undergo a few conversions. All these are important details you need to know, because what you don't want is to give the keys to somebody and then later find out that all sorts of alterations have been made on your property without your knowledge, and now you're stuck with having to reset the property for normal residential use. Other businesses that might come would be daycare centers. You might have somebody who wants to use your house as a daycare and each of the rooms for different age groups. This is also a common thing that happens from time to time. And again, it's going to be very difficult for you to know who's on the property because it's constantly changing and it's a lot of people. So do you know who's there? If you don't, it's even a greater degree of suspicion. Number 3, is your rental located in a deed-restricted neighborhood? It might be, and because of that, it might be that business activity is prohibited, and immediately upon the business signing that lease and opening their doors for business, you're going to get hit with HOA violations. You absolutely need to know before you ever enter into an agreement like this whether it's even possible for you to get by with it. And this includes short-term rentals, right? If someone wants to rent your property because they want to Airbnb it out, you better know whether or not your HOA will allow that, because you may be stuck with a tenant who can't operate their business and therefore doesn't pay your rent. Does your landlord insurance cover claims for business activity? This is probably a big fat no. Check your policy. If it's a standard residential policy for a residential tenant, it's not going to cover commercial activity. It's not going to cover workplace injuries. It's not going to cover slip and falls when invitees are there. These are the customers. And it's not going to cover things like some employee comes and tumbles down the stairs while conducting work activity. These things probably aren't going to be covered, but it's possible that these third parties who are injured come after you, the homeowner, if, for example, that particular company is some fly-by-night company with no assets, and they're gone, after some big nasty injury, and now you're stuck with that bill, and your insurance is not going to step in and protect you. So a bunch of things to consider. The last one is there a qualified individual where the buck stops? Is there a qualified individual for that business who says, I will personally guarantee this contract, who themselves would qualify as a tenant to pay off this lease? They have a suitable amount of income, they have a great credit score, they have no criminal activity, and they've never been evicted before. All these things are absolutely necessary for you to know before you lease to a regular tenant. Of course, you would want to know these if you're taking the step and leasing to a corporate tenant. I'll tell you that right off the bat, I get a little queasy when people talk to me about the possibility of leasing residential property to a business. These are definitely things to consider. And unfortunately, when you consider these factors, you end up getting some bad information back that I would say is extremely discouraging and frustrating to the landlording process. So in a nutshell, no, I'm not in favor of these kinds of contracts, and I don't typically recommend them. So let's go ahead and go on to our questions. We have 4 questions here today. Again, any of you who are joining us live who want to add a question into the chat, I'm happy to answer those questions. So here we have KS asks 2 questions. If an agent entered my listed home without authorization, can they be held accountable? Is this a TREC violation? Now, TREC is the Texas Real Estate Commission. And the Texas Real Estate Commission, steps in and regulates real estate transactions, the buying and selling of real estate. And there are certain rules that parties have to follow. I'll tell you, I don't do a whole lot of litigation between realtors, that sort of thing. And so here's what you have to ask with a question like this. What is the authority that is given to all realtors? If you've got a blanket authority that any realtor can come visit the property, and you leave a mechanism on the door that any realtor has access to, well, you've already given blanket authority, and you kind of can't stop people who are going to come onto the property. So if that's the case, I don't see how you've got a claim. If that person broke into the property somehow, that sounds like a criminal action. Otherwise, how did they get access? So if they were granted access, there's probably no harm in that. But certainly if they broke in through some illegal means, that's a police matter. You'll want to take that with the police. I doubt it. My guess is that they probably got in through the normal way that realtors access property. So, question 2, if a buyer defaults on purchasing property, can a seller collect the earnest money automatically? Here are the facts. Buyer sent over a termination agreement after the deadline passed. So obviously there was a set closing, the deadline passes, and the buyer says, hey, let's sign this agreement and then part ways. And they're saying that the reason that's a reason determination on the termination agreement is that the house for sale has rats, but it doesn't have rats. Title company does not want to give me, the seller, the earnest money unless I sign the termination agreement, even after they, the buyer, are in default. I don't want to sign that because I had an inspector come in. He said the exact opposite that they said. I've never had this problem. I don't have a problem, and I don't want to sign something that is on the record about my home, but I do want the earnest money. What should I do? Can I strike out their language or put an addendum on my copy that says that? Inspection report that shows I do not have rats. Okay, so let's talk about when a third party is holding earnest money subject to a written contract, and there are terms outside of that contract that affect how that contract is interpreted. What this describes, what you have described, is the kind of stuff that we go into courts every day and fight about. These are contested elements of the contract. How was it carried out? Were the deadlines met? Was there cause for termination? These are fact issues that a court will determine. So if you're asking me, is there some automatic trigger that ultimately allows me to go and just grab the earnest money? No, there isn't. The title company, whoever's holding the earnest money, they work as a neutral party. They're not there to decide whether you, the seller, are right or they, the buyer, are right. What's very easy is when the buyer and the seller sign an agreement that says, we will close, and on closing, this money gets applied in this way. If we don't close, then based on this new agreement, in this case, termination agreement, the money can be distributed this way. That's very easy. It doesn't require any real thinking. It certainly doesn't require a determination of fact. That's not what the title company does. That's what a court does. Whether it's in front of a jury or in front of a judge, the fact finder will determine which party is culpable or which party is eligible to receive the funds. And so, again, you've got disputed facts here. The only way you're going to get this earnest money outside of an agreement is with a lawsuit. And it's unfortunate that it comes to that, but you're going to have to sue these parties and go into the courthouse and duke it out. And so the question for you is it worth the time and effort to go through all that for what's left, for what's in the earnest money account? I don't know, it might be. And so I'm not trying to discourage you. I'm just saying this is the process. And sometimes it's easier to just say, look, let's just, you want to go halvesies. I don't believe that's right, but I will go 75-25. You fork over 75%, you keep 25%. Otherwise, I'm going to sue you for the full. And if it turns out that you are right, you might, on top of the earnest money, be able to collect all of your attorney fees, court costs, and then interest thereafter. If the party on the other side is worth suing and has something to lose, it might be a good idea for you to make that threat and follow through with that threat if they don't capitulate. So no, there's no automatic trigger that automatically the title company has to give you the money. When there's a dispute like this, you either reach a settlement or you file a lawsuit. All right, so we've got MM. Hey, E, thank you for the videos. If a tenant's been evicted, here's a question from MM. Who reports the eviction to the credit bureaus? I hope you do a video on small claims court to collect money owed after an eviction. So bad news. This didn't always used to be the case, but as of 2018, credit bureaus no longer report judgments. And so an eviction cannot be featured in a credit report. Instead, it pops up when you do a tenant screening for companies that screen specifically for eviction judgments. So that'll pop up then. Well, let's say you have a judgment where you have money owed from a tenant. If it doesn't come up in the credit report, well, what can you do to record it and possibly seek some mechanism to collect it later? Well, what we advise here in Texas is that you get an abstract of judgment and then take that abstract of judgment and record it with the property clerk's record in your county. This then establishes a judgment lien, which you can later collect through a process called a writ of execution. And you can potentially exercise that lien through a constable sale if, in fact, the tenant owns non-exempt property. For example, let's say you sued a couple and they ended up through judgment owing you $5,000, and you recorded that abstracted judgment with the county, and they continue to live in the county, and they, as you know, had 3 vehicles, 2 drivers in the home, but 3 vehicles. And so the law says that each of the drivers gets a vehicle. So that's 2. But if there's a 3rd vehicle, that vehicle is potentially subject to seizure. If it is titled in the same name as the people who are featured in the judgment, you might be able to seize that through, again, that writ of execution. The constables can then hold a constable sale, and the proceeds of that sale can then be applied to your judgment. This is also true of real property, maybe a vacant plot of land, maybe land that has a house on it, but it doesn't apply if it is their homestead. So any non-homestead land that is owned by them is also subject to seizure and also subject to a potential constable sale through the writ of execution process. So again, you start off by abstracting your judgment and recording it as a judgment lien, and then following through with the execution process to conduct a constable sale. J.O. writes, is there a way of reporting on-time rent payment and late rent payments to credit bureaus without the landlord paying a fee? There's not any way that I know of this. There are services that allow you to do this. The only service that I've seen that gets close to this does it in a way that I'm not super comfortable with, because while it does apply to the tenant, it doesn't necessarily name you, the individual landlord, as the beneficiary of that rent or the holder of the debt. Because of the complications with credit reporting. It's actually a nationwide company, and they sort of put the debt under them as an umbrella, and they report that debt as non-paid through the credit bureaus as though it's associated with them. So it's technically possible, but there are fees involved, and again, I don't see a whole lot of benefit to individual landlords in situations like that. It's reported, but it doesn't have a direct link back to the landlord. I think the better thing is to abstract the judgment, and if non-exempt property is found, that's your best bet that you're going to get something in return for your judgment. And if not, then and you can just move on. Okay, question 3 comes from M.A. Cumby, who asks, regarding deposit return, the Texas Property Code states, if a tenant does not give the landlord a forwarding address, tenant is not relinquishing their right to their deposit. In other words, the tenant can give their forwarding address when some time has passed since their move out, and we are obligated to refund at that time. Does this right to their deposit exist in perpetuity, or is a statute of limitations applicable? Thank you. So good news, no, it doesn't exist forever, and yes, a statute of limitations does apply in this situation. So here's the rule. You've got a tenant in place until a certain date. And on that date, the lease has come to an end. There is no more lease between you and this tenant, and the tenant has in fact vacated. So they have surrendered the property, and on that same date, they gave you a forwarding address. Well, in Texas, the basic law is you got 30 days to get them back, either an itemized list of all deductions explaining why none of the deposit is coming back, an itemized list of deductions explaining why some of the deposit is coming back, or the full deposit returned to the tenant. So 30 days to get that once you've got termination of the lease, surrender of the property, and that forwarding address. Okay, well, let's say the lease is terminated and the tenant surrenders, but they never give you that forwarding address. And let's say 5 years later, they call you up and say, hey, I never got that security deposit from you. I'm going to sue you. Well, at that point, there's no way for them to sue you. In Texas, for a breach of contract matter, the tenant has 4 years as part of the statute of limitations to sue you. In this case, the breach would be non-return of the security deposit, also known as wrongful withholding of the security deposit. But the clock for your obligation never started ticking. That 30-day clock never began. And so they technically didn't have a cause of action against you for any wrongdoing whatsoever. And because their right to that deposit terminates after 4 years from the date of termination, they lose after 4 years their right to make a claim for the deposit. Now, what is it that I recommend by default should happen between every landlord and every tenant in this situation? Well, you probably have some outlet to contact your tenant. So instead of just waiting to see when they'll contact you, and most tenants who expect their deposit will contact you, and most tenants who know they're losing that deposit simply won't contact you, maybe because they owe rent or they did extensive damage on the property. But when it comes to what you can do, I would always say, don't wait for them to give you a forwarding address, especially if you know the entire deposit's gone. I would, and this is what I always recommend to landlords, calculate every fee, every dollar owed to you by that tenant. If fees, maybe HOA fines, maybe unpaid rent, all sorts of stuff, accumulates beyond the security deposit, itemize that list, send it to them within the 30 days, as if they had given you a 30-day, as if they had given you a forwarding address. You may have, an email address, but even if you don't have an email address or a number to text or some other method, you can always mail it to the unit. If they forwarded all of their mail anyway, guess what they're going to get? They're going to get that letter forwarded to them at their new address. So you cover your base in terms of updating the tenant and letting them know how the deposit was applied. Now, if it turns out that after all valid deductions, you have a rent balance, you can also mail a check to them in the exact same way. If they are having their mail forwarded to them, they'll receive it, and you'll be able to see through your checking account whether or not they actually cashed that check. Now, it is possible that a check gets lost in the mail or that they don't forward it and it just ends up going to the mailbox at the residence. So what do I recommend in this situation? Take back that letter, hold it, don't open the envelope, because in a potentially subsequent lawsuit against you, when they sue you after never giving you a forwarding address, you can show the court, not only did I never get a forwarding address, but I attempted to mail this to them at the last known address, and here it is with the marking from the U.S. Postal Service, and so my bases are covered. If you never get that forwarding address, the clock never starts ticking, and if more than 4 years have passed, their ability to collect that rent ends because your obligation to them ends after 4 years from the date of termination of that lease. So no, it doesn't go on forever. But unfortunately, yes, if in year 3, month 9, they finally get that forwarding address to you, you are still technically obligated to send out that notice and issue a refund if a valid refund is owed. So, okay, NO writes, if a tenant, if a tenant sent a notice to vacate, If a tenant sent a notice to vacate? If a tenant sent a notice to vacate and then could not find another, if a tenant is sent. If a tenant is sent a notice to vacate and then could not find another apartment, if in response the landlord gives the tenant extra time to find a place, is the tenant considered month to month despite sending a notice to leave? Well, this is why I strongly recommend that all communication between landlord and tenant be conducted in writing. This is extremely important. If you send a notice in writing and then say something orally and the judge hears that you did this, the judge could take the side of the tenant and establish that, yeah, you and the tenant worked something out, because I don't know precisely what the agreement was because it was only spoken. But I find the tenant's testimony believable that even though you sent this notice to vacate, you agreed to let them stay rent-free or some other ridiculous thing until they were able to find something. And so I don't recommend, first, any communication that isn't in writing. But second, if you do allow a modification of your notice to vacate, why? I mean, if you're getting money in the meantime, yes, you've probably established a month-to-month tenancy, which can only be terminated with a 30-day notice now, or if there's breach of the terms of that tenancy with subsequent breach. So I always tell landlords, don't send a notice to vacate unless you mean it. If you mean it, then follow through. And if they need more time, guess what? The same thing I tell landlords all the time. Time is built into the system. 30 to 45 days in the state of Texas, usually. You send the notice, you wait the time, you file, and then you get a trial setting. And so if in all that time they don't find something, when the law really only gives them 3 days, 30 to 45 days is plenty of time. If they don't find anything, they're just not looking. And so I wouldn't stop anything. I would, if you're going to send that notice to vacate, follow through and then file and then show up to the eviction trial and then get your writ of possession as needed. Again, the fact that you're working with them shouldn't include you're delaying the eviction process, because delay is built into the system. Okay. So last question. This is from Marty. And again, I want to thank everybody who joined on a Friday afternoon. I know it's not the same as Wednesday. I should be back on next Wednesday with our topic, which I'll reveal in a little bit. But first, let's get to Marty's question. Marty asks, I would like to start an LLC for rentals, but I'm not sure if it would work as the two rental houses are now on the same property I live on, and all are part of one mortgage in my name. Not sure how it works. So unless you're going to subdivide, and the way I understand it, you've got one piece of land with 3 properties on it. I live in one, I lease out 2, and I lease out 3. Well, if that's the case, if all 3 units are on the same, I got 2 rental houses on the same property. I live the same property where I live, and it's part of one mortgage. So maybe I'm misunderstanding. Maybe it's 2 rent houses and the individual, and Marty lives in one of them. But what matters is how the land is titled. And so it could be a piece of land. It's one deed with 10 houses on it. It could be a piece of land, one deed with 1 house on it. It's really who owns that deed, who owns that title. So the number of houses on the land really doesn't matter. So let's say you want to transfer that house to an LLC. Well, you did mention there's a mortgage. And typically when there's a mortgage, you have to consider whether or not you have the right to change the name on the mortgage without express written permission from the lender. And so I always recommend to landlords, in this situation, you're going to want to reach out to your lender and get written permission. It's not enough that they told you over the phone, oh yeah, that's cool. We're not going to worry about that. Get it in writing. If you don't have it in writing, then I can't recommend that you make this change, especially if I don't know whether or not your loan agreement has a due on sale clause, which says the moment you transfer this property to another person or entity, we can foreclose because we have a due on sale. It looks like you sold it, and so now we need to collect our loan proceeds back from you immediately. So yes, you can get permission. Let's say you've gotten permission, and now you want to establish your LLC. Yeah, I mean, you can definitely establish it as long as you have that permission from your lender, and you can. Again, same property, but multiple houses on it. Doesn't really matter because, again, the property is under the same deed. You get an LLC, then you transfer the deed to, 123 Marty's House LLC, or whatever you want to call it. And now the LLC is the owner of both your property where you live and your rental property. And so you can conduct business under that LLC and continue to lease out under the name of the LLC. And now in this case, it's your residence. So you're not really separating your residence from your business property. It's a little complicated with the way things are set up here. And what could be available to you is you could petition to your county about establishing a partition. And maybe what you sell to your LLC is just the half of the property that applies to the business of renting. If you're going to live in one and take a homestead deduction on it, and you want to lease the other and use it as a commercial property that is owned by your new LLC, that's something you'll have to run through your county in terms of partitioning out your large lot into 2 smaller lots. That's a little more complicated than I think you asked, but that's one way you could do it. Stay in ownership of the one, but split the other. Now, whether you can do that while you still have this promissory note is probably no. So you'll probably have to get the lien released before the lien holder will allow you to do that. Otherwise, that's an option available to you as well. But again, to do it, you can't just arbitrarily do it. You're going to need the permission now of the county where the property is located, and that's its own set of complications. So I want to thank all of you who joined for the live today. Again, we'll be back next Wednesday. Assuming I don't have some kind of trial going on next Wednesday. Let's take a look at the calendar. And no trials on Wednesday. I should be good. And so next Wednesday's topic is, how is property management different for a remote landlord? If any of you have property outside of your county, outside of your state, I know we serve a lot of landlords outside of the state of Texas who have property inside the state of Texas. How is property management different for those remote landlords? If you've got a question about remote landlording or any other landlording topic, naturally we welcome you to join us here live. If you're not a member of Texas Landlords and you are a landlord in the state of Texas, I welcome you to check out our Facebook group where we announce these lives and where you can ask your questions ahead of time. For those of you who did, I thank you for that submission. For those of you who joined the live and asked questions, I thank you. And until next time, landlords, happy leasing.